So, good afternoon. My name is Jane Goodman-Delahunty, and I'm a research professor from Sturt University. My background is both in experimental psychology and law, and I'm very pleased to be here today as a guest to talk about my interdisciplinary research with a very evidence-based focus. So I'm going to be talking today about some empirical legal research that has been done on the topic of human memory, with specific reference to how people remember experiences of child sexual abuse, and in particular, what we call historical cases of child sexual abuse. An historical case of child sexual abuse is one where the abuse happened many years before the reporting of the abuse, because many cases of child sexual abuse are in fact never reported at all. And most typically when they are reported, there's a substantial delay between the events of abuse and the reporting. So the case that I'm going to be focusing on today is a case against Cardinal Pell, who is one of the most senior officials of the Catholic Church worldwide. And these events took place during a period when he was an archbishop in Melbourne, Australia. And I'm at the moment from Australia, so this case has had enormous publicity in the Australian context, but also worldwide in the Catholic Church. And it is an historical case because there is a time lapse of decades between the time of the events and the time that they were reported, approximately 20 years at least, maybe more. So you'll see the dates that we'll talk about, but that is why it is a case of historical sexual abuse, and there are some special issues about human memory and the kinds of evidence base to draw on in assessing memories across the decades. So this is a picture of Cardinal Pell, who is the defendant in the lawsuit that I'm going to be describing to you. I just want to give you very quickly an overview of the case chronology that we're dealing with. So the complainant first reported that he had been abused by Archbishop Pell at that time in 2015. But the events in issue took place in about 1996 and 1997. So you can see the gap between the events and the reporting. And then, of course, there's a bigger gap between the time of trial and the events. What the complainant reported to the police was that when he was approximately 13 years old, he was a choir boy, and with another choir boy, the two of them alleged that George Pell had sexually abused them on two different occasions. So there are two incidents in issue. The one incident is alleged to have happened inside the Catholic Church priest's sacristy. The sacristy is a special room where the priest went to remove the robes, and they also kept some of the holy wine for the communion. And the priest would go in there and usually accompanied by another person. And the two boys had run away from the choir procession. They were young 13-year-olds and they were finished with their singing, and they had taken off on a diversion, and they had hidden in the sacristy. So they alleged that the Archbishop Pell came into the sacristy, found them there, and abused the two of them. So that was the first incident, and it was a serious allegation of sexual abuse, including oral rape by George Pell. The second incident is alleged to have happened approximately 3 to 4 weeks later. this time not in a closed room like the sacristy, but in a corridor that was used to get around in some of the quieter parts, leading between the area where the priest would speak from and move around, separate from the public though. And on that occasion, the complainant in this matter alleged that he was touched sexually on the genitals by Archbishop Pell in this corridor. So those are the two core events. The second victim, who was present in the sacristy, had an unfortunate life as he grew up, and he was not a co-complainant in this lawsuit. He was deceased at the time of trial. When the case came to trial in 2018 before a jury, there were 5 charges, and only one complainant was left to talk about them, because the second complainant, the other 13-year-old boy, who was the victim, had died of an accidental heroin overdose some years before, and he never reported the abuse to the police. So it was a case of one complainant's evidence against the institution of the Catholic Church. And the jury trial proceeded in Melbourne, Victoria, and the jury finally was given the charges by the judge. They deliberated for almost 4 days, and the jury returned a unanimous guilty verdict against Cardinal Pell. So this case received immense media publicity. George Pell was sentenced to 6 years in prison. He will be eligible for parole in 2022. After serving only 3 years and 8 months, you can get early parole. So now he is 78 years old. He is still in prison. And with the support of the Catholic Church, he has filed a series of legal appeals. So I'll talk just a little bit about some of the decision-making factors. The first appeal that was filed was an appeal to the Victorian Court of Appeal, and it was decided by 3 different judges because the panel of Court of Appeal judges is constituted by 3 persons. When they had to reason about the veracity of the claims, they focused on some doctrinal law factors, and I've listed those for you on the slide. They're called the Eggleston factors, and there are 6 factors that are crucial to assess the evidence if you are a judge looking at what a jury has done. And you have to assess all of these 6 factors, and they discussed them in their opinion. Very important is just the intra-individual consistency of the witness, so that would be the complainant. Was his story holding together? Consistency between his evidence and that of other evidence to cross-check it. Consistency with other undisputed facts that everyone agreed about, that had, for example, to do with days that Cardinal Pell had been in the church giving a sermon versus days that he had not, so that it was clear that those were days when the abuse could potentially have happened. The credit of the witness in terms of was there any motivation that he had, perhaps to be lying or to give false evidence? What kind of demeanor did he have in the witness box? Was it one that seemed to have a ring of truth about it or not? So there was the observation of the witness that the jury had, and of course, most typically, the appellate court would not have a chance to observe the trial witnesses in person. But because in our legal proceedings now, in cases of child sexual abuse, the police have a practice of pre-recording the evidence of the interview. There are often videotaped interviews of the police statement by the witness that is played to the jury, and so even appellate judges can watch the video. In addition now, in order to avoid re-traumatizing a victim of child sexual abuse, all of the trial proceedings are videotaped, much like this lecture. And so the people who might never have had a chance to observe the demeanor of the witness, in this case the Court of Appeal judges, had a chance to watch the entire trial just as the jury saw it. and so were able to form their own impressions about the demeanor and the credit of the complainant as well. And the final of the 6 Eggleston factors is the likelihood of veracity, the probability that what he said was true versus the implausibility or improbability of it. So all 3 appellate judges used those same 6 factors in reviewing the jury verdict. And it's what we call a reasonable doubt case. In other words, the major challenge is whether other legal scholars looking at exactly the same evidence as a jury would find that there must be reasonable doubt, that it can be construed as an error of law if in a reasonable doubt case the judges reach a different conclusion from the jury. So the way that the Court of Appeal decision turned out, and it was issued earlier this year, 2019, was that there was a split decision between those 3 appellate judges. So 2 of the judges, the majority, affirmed the jury verdict. And they said that it was open after their review of the evidence that the jury had reached a correct verdict. They could have been satisfied based on all of that evidence beyond reasonable doubt of Cardinal Pell's guilt. And they were not behaving unreasonably. There was therefore no error of law. And they said that in 125 pages with lots of reasoning. The dissenting opinion was 175 pages long and reached the opposite conclusion, saying that after reviewing that videotape and looking at the Eggleston factors and all of the witnesses who testified for the defense, and I'll come to those, the jury had made a mistake and there was definitely reasonable doubt of Cardinal Pell's guilt. And they summarized primarily problems with the complainant's account, such as inconsistencies in the evidence that he gave at trial, discrepancies between his evidence at different times and that of others, and they also argued that it was simply impossible for the events to have occurred in the way that he had alleged, and that a number of his answers made no sense. So that's how the Court of Appeals finished. And then after that, in a last-ditch effort, a final challenge to be released from jail and have this verdict overturned, now Cardinal Pell has appealed to the Australian High Court. And the High Court last week, 1 week ago exactly today, agreed to take on this case. And it will now go in front of 7 judges who will no doubt see the same videotaped evidence as the jury and the Court of Appeals, and will reconsider these same issues. And so the question about memory lurks very strongly in all of this, because it's what we call a word against word case. There are no corroborating witnesses. The sole potentially corroborating witness is deceased and made no statement. There's some controversy just as to whether this actually is a good case for the High Court to take on, because normally they only take on a case if there is a question of public legal importance. And the argument that the prosecution has made now is that the facts of the case are settled. They've been thoroughly explored by the jury and reaffirmed by the Court of Appeal, and there's nothing more that the High Court can do. But when that dissenting judge wrote his 175-page opinion, he was targeting it, I guess, for the High Court. And he has now argued that the Court of Appeal flipped the onus of proof, and that instead of saying that the prosecutors had to establish the case beyond reasonable doubt, the Victorian appellate judges, placed the reasonable doubt burden on the defense. So that is the legal argument that is being made to our High Court. What are the central facts in controversy? Well, the defense has alleged that it's a case of impossibility because there was no opportunity for the offending in the sacristy and in that corridor to have happened, due to the fact that the Catholic Church procedures were invariant, and very well established, so that most typically no archbishop could have ever stepped into the sacristy alone without another accompanying church official with him, and that therefore he would have been unable to engage in those acts of sexual abuse with the boys. The prosecution said, it's all very well for you to have practices and protocols, and a whole series of defense witnesses called the opportunity witnesses spoke about the practices and protocols that were set over time. In fact, about 20 of them gave evidence along that line. But the prosecution's argument is, it doesn't matter what the protocol is, we need to plumb down on the memories of what actually occurred on the specific occasions where the boys have alleged that abuse occurred. And that brings scientific research on two types of memory into sharp focus. So on the one hand, we have what I am calling conceptual or semantic memory, and on the other hand, we have what I'm calling episodic or event memory. So episodic memory is the kind of memory that occurs when you are experiencing something directly. And through your five senses, you absorb information from the event around you, whether it's visual or auditory or tactile, and so forth, from all of the five senses. And then a memory trace, rather like forensic trace evidence, may be generated. That is then first captured in your short-term memory and then transferred through a process of consolidation after the encoding into your long-term memory store, and that can then be retrieved later on by an appropriate retrieval cue. You hope to reactivate that memory trace and retrieve a memory of that episode or that initial event. So the prosecution is asking that we focus on that sort of memory process. The defense is saying that all of these practices and procedures that occurred are definitive, and those are repeated events. And one of the things that I'm going to be speaking about today, when I speak about semantic memory or conceptual memory, which is not directly obtained, it is indirectly obtained memory, such as learning in a classroom where you don't necessarily experience everything directly, you learn about it secondhand, and you might then develop a series of concepts or general knowledge. It's a different kind of memory base. And oftentimes when we experience something over and over and over again, through a repeated event, we encode that information differently than we do the episodic memory. And the retrieval process for memories that are repeated are somewhat different than those, and the way we make sense of those experiences a little different than those to do with episodic event memory. So I'll come back to that point later on, but I think that is the core memory controversy between the prosecution, complainant, and the defense witnesses called the opportunity witnesses. And that has to do with, at the end of the day, making a decision as to whether the story by the complainant was inherently probable or inherently improbable, that very key Eggleston factor. All right, so I've highlighted that this is a word against word case, and that the key issue is whether the complainant's evidence is honest and truthful. In other words, was he lacking in deceptive motive to make up a story? But secondarily, is his evidence accurate and reliable? What kinds of factors might have been present that affect the accuracy of memory, even if you're sincere? We know from a body of research on human memory that people can have sincere but incorrect and inaccurate memories. And the trial judge emphasized the difference between deceptive and erroneous memories to the jury before they deliberated. I think in looking at the judge's decision, it's always interesting to consider the fact that, as I've highlighted, people often accept that they can have incorrect memories and that memory is fallible. People are less ready, as François de la Rochefoucauld pointed out, to accept that perhaps their judgment is erroneous. So now we have a case where the judgment of the jury, the judgment of the Court of Appeals is going before our High Court to focus not only on fallibility of memories, but also on fallibility of the judicial reasoning. And so our question today to explore in depth is, where does the evidence-based consensus lie regarding those episodic versus those semantic or conceptual memories at stake in this case? I will be drawing on a body of empirical legal research. So I want to just give you a little bit of background as to how we generated some research on historical memories of child sexual abuse for the Australian Royal Commission into Institutional Responses to Child Sexual Abuse. We had a 6-person commission, and you can see the photographs of our 6 commissioners on the slide, who had a project that they were given by the Australian government, by Julia Gillard, in approximately 2012, 2013, to examine issues of institutional child sexual abuse. And by institutional, they meant schools, they meant prisons, they meant sports organizations, and also religious institutions such as the Catholic Church. There were a number of other different institutions in Australia that came under scrutiny. And in the course of hearing the voices of many complainants during the tenure of this commission, the commissioners in fact held private hearings with approximately 7,000 different individuals who reported their experiences of institutional child sexual abuse. And some of those have gone on to be litigated now in courts. But I think it's really important to understand that this special commission was set up to consider some legal reforms that might be implemented in the legal system, but they took all of this evidence outside of the traditional court process. And what was really unique about the way that the commission operated under the leadership of Justice McClellan, who is seated there a third from the left, a third from the right, if you're looking at the slide, is that they decided to adopt a purely evidence-based approach to the reforms that they were going to consider. And there wasn't even a sufficient body of research on this topic to inform them as they went about looking at this topic. And so they commissioned approximately 100 different empirical studies by Australian researchers who do work in the fields of psychology, criminology, social work, and so forth. And in fact, they exhausted many of the academics who work in that field within Australia, and even used some researchers in other countries to fulfill those 100 studies. And I was fortunate to run 3 different projects for the Royal Commission. And the one that I'm focusing on today is the work that we did on complainants' evidence on historical cases of child sexual abuse. I do need to acknowledge at this time my 2 chief co-authors on this project, Professor Mark Nolan from the Australian National University and Dr. Evian van Geen Grosvenor, who's at Macquarie University in Sydney. The 3 of us spearheaded a project that the Commission requested to try to draw together all of the memory research that bore on this topic. Those of you who are familiar with empirical studies on human memory will know that this is a vast, vast literature. And so one of the first undertakings in our method that we had to discern was where to start and stop. And as we scoured through the research just on human memory, looking for more autobiographical memory than just event memory, and especially realizing that most of the database that exists is about eyewitness crimes rather than personally experienced crimes. We were fortunate to find some empirical guidance that had been drawn together by the British Psychological Society. And the British Psychological Society published their final report on memory guidance for the courts in 2010. They initially produced that report in 2008, and then there was a conflict amongst the British Psychological Society that raged for about 2 years before they finalized the report in 2010. And that had to do with the topic of who was a qualified expert on human memory research to provide guidance as an expert witness in court. And initially they said that only primary memory researchers could undertake that task, possibly because most of the committee members, the international committee that put together the British Psychological Society guidelines, were in fact mostly primary memory researchers. But the clinical psychologists in Britain who deal with the victims of child sexual abuse felt that they were being ousted from the expertise that they could share on the topic. And so finally the guidance on who could qualify was broadened in the British guidelines. What was really important to us was that they had canvassed all of the literature and produced contemporary guidance through 2008. So we began our literature search in 2008 through 2017. And we had a team of approximately 26 research assistants who helped us to coalesce all of a large database of approximately 650 to 700 empirical reports, as many meta-analyses as we could find, using a number of search engines. And then we divided that literature into different subtopics that had a bearing on memories of historical child sexual abuse. And you can see how we compiled this report to the Commission. It is available on the Royal Commission's website. It's also available in a PDF version, and if anyone is interested in reviewing our report, please do email me and I'll make sure to send you a copy. I'll just give you some guidance on how to approach it. There is an excellent glossary to this report that is not listed there because we realized that we were dealing with an interdisciplinary audience and that many legal scholars and consumers may not be acquainted with some of the really technical terms that you encounter in the empirical reports that we were discussing and summarizing. So we wanted to ensure that there was a good glossary that could summarize for people, for example, a definition of episodic memory, a definition of consolidation of memory, a definition of retrieval, and a definition of conceptual semantic memory, etc. The final appendix that is listed there, Appendix 10.1, is about a 6.5 page condensed plain English, plain language summary of the entire set of findings by topic, really intended to give some guidance to courts that could be used in instructing juries and could be used to try to develop, because they are research-based and evidence-based, some empirically based jury directions that are very different than the kind of jury directions typically given in historical cases about delay of memory and inconsistencies of memory, etc. So we were looking forward across time for that option. There is an executive summary in the front as well that we haven't listed here. I focused here on the kinds of topics and the way we divided them up. And you'll see that one of the topics that I've highlighted is very crucial in the Pell case is in fact Chapter 7 about memory for recurring events, because that's what all of those opportunity witnesses were talking about. And of course Chapter 5, dealing with delay and memory, is also key. In addition to having this large database search and culling down the studies and summarizing the findings, we did gather expertise from other memory psychologists and researchers and clinical psychologists in the Australia and the New Zealand community. And with the Royal Commission, we convened a public roundtable that was attended by approximately 23 different researchers who deal with eyewitness memory or autobiographical memory or child development memory, as well as individuals who provide therapy to sex offenders and look at sex offenders' memory or victims' memory, and people who provide therapeutic sessions and counseling to victims of child sexual abuse. And you can also, if you click on the link that is listed there, you can bring up a copy of this full-day transcript of the discussion among the experts. So what we did before that roundtable was convened is we sent a draft copy of our report to all of those experts and asked them for feedback on every single chapter to ensure that we were drawing on the consensus of opinion, not only from the literature, but a kind of a peer review from our contemporary memory researchers in Australia and New Zealand. One of the highlights that you need to foreshadow working in this area with is, as I said, to distinguish memory of child sexual abuse from the research database on eyewitness memory. And this slide over here is simply a synopsis or a summary of some of the key differences between what you mostly find in empirical studies on human memory and the kinds of issues that come up in cases of child sexual abuse. Now, you may not know the volume of these cases in all of our courts at the moment, but in the Australian context, at this stage, approximately 50% of the caseload by prosecutors is cases of sexual abuse. So it is a very high profile area, not only for the prosecutors and the defense lawyers to work with, but also for members of the judiciary to become acquainted with some of the specific aspects of how memory for historical events plays out. So I've highlighted that in both child sexual abuse cases, as well as many of the experiments on eyewitness memory, certainly episodic memory is well tested. So we drew on that research a great deal. But then the differences emerge. So oftentimes in the research, because it's not ethical to abuse people and then see how they respond to it in an experimental study, there is no such experience that is validated in the experimental literature. Sometimes people do what we call analog studies, where they follow people who've had some kind of traumatic personal experience, such as exposure to an earthquake or exposure to some other kind of natural disaster, or perhaps some dramatic childhood accident with broken bones requiring a hospital visit, where there is corroborative evidence about the treatment given, what happened, documented in medical and clinical notes. And those kinds of studies have been more informative to us in terms of autobiographical memory, as opposed to things that are not personally affecting in the eyewitness memory literature. The kinds of events that we were interested in were typically events that were negative for the participant. So that ruled out a lot of observational events in the eyewitness literature as well. Usually in an eyewitness study, and the vast array of studies done that have led to guidance for the courts, the identity of the perpetrator is the key issue. There are eyewitness memory cases on facial identification primarily. This is the opposite of what is happening in most cases of childhood sexual abuse, where the perpetrators are very well known to the victim and identity is not the issue. So that's a distinguishing issue in the literature. In fact, there's usually a prior relationship of quite some long standing, especially in intrafamilial cases of childhood abuse, where it's the perpetrators are parents, but oftentimes also in institutional cases where the perpetrators are authorities who are in teaching roles or some other role of authority or guidance over the victims, as in the Pell case. There is oftentimes a relationship that projects into the future as well, that can change the incentives of individuals to report the abuse. And can, for example, if it's a parental sex offender and the child is afraid that the parent who's the abuser is going to be imprisoned and go to jail, that may have a dramatic economic impact on the livelihood of the rest of the family. It can split families apart. So there are many emotional reasons associated with looking forward to those ongoing relationships that can impact the kinds of narratives that are reported to police. And what we often find is that there's a gap between the memories that people have of this kind of abuse and what they will say to authorities. And those ongoing relationships and many times efforts to want to preserve the good parts of a relationship with someone that they've known for many years, notwithstanding abuse, can be very confusing and counterintuitive to fact finders who are not familiar with this literature. The personal life significance is distinguishing in the literature. I've highlighted that. Of course, we're dealing with autobiographical memory. Once something such as an abusive experience occurs, it can change somebody's trajectory in their life. It can have a huge impact on memory processes as well, especially where serious trauma results. Approximately 50% of individuals who are abused develop post-traumatic stress disorder. 50% do not. So it's not a predictive factor that is reliable, but people who have post-traumatic stress disorder can oftentimes have very different kinds of autobiographical memory because of that trauma. So we'll come back to looking at that feature as well. The consequences of the memory report I've alluded to by stressing that it can mean that people are going to, go to jail. That's not what happens in many experiments. And the number of reported events is a distinguishing factor. Previously, I've done some evaluations of clinical samples of, for example, a pre-trial detention intervention program for parental child sex offenders, where we had a database of approximately 250 parental sex offenders to work with, and we were able to match the accounts of the victims with the accounts given by the offenders. And the striking feature in that study, which we've published, is that you're not talking about a single one-off event of abuse. That's very, very rare, probably less than 1% of the child sexual abuse cases. Most often, the abuse is protracted and repeated, and although the Pell case has two critical events, we ran across cases in our database of these familial child sex offenders where there were over 1,000 repeated events of abuse. So you're dealing with a very different kind of memory in many of these cases, not so much in the Pell case where you have two primary episodic events. And a meta-analysis of the research on eyewitness memory showed that the major time lag between exposure to, for example, a staged crime or a video of a crime that is the stimulus material for the research participants and the memory test to see whether or not their memory is accurate and reliable is between 0 and at the most 2 days. So there's a very, very short time lag in most of the literature. Whereas in real life, in these historical cases, as you can see with the Pell matter, with events transpiring allegedly in 1996 and the trial in 2018 and the police report in 2015, the time lag is vastly different. And so what we know about how memory endures became much more important in our research review than was available in some of the literature. So what have some of the best research psychologists done with regard to providing insights for the legal system? we were able to draw on a study that was as of yet unpublished when we did our review, but it's published now. And I want to highlight this study in particular because of its methodological strength. So this is a study by some British memory psychologists trying to provide better insight into what people know about human memory that might impact their ability to serve as good jurors or as good judges or good appellate court judges or high court judges by exploring the extent to which people's knowledge of human memory in these cases matches the research database. So what Akhtar and her colleagues did was first they did quite a bit of preliminary research where they had, I think, at the initial phases, about 56 to 60 statements about memory that they fielded to people to see how they agreed and disagreed with them and what sort of factors were present. And then from that, they culled it down to about 36 key statements. And they put those 36 key statements that addressed 5 different topics about human memory in a written survey. And the topics addressed were just fundamental things about how memory works, the nature of memory, what makes memory more or less accurate, what is the relationship, for example, between exposure to a traumatic event and accuracy of memory. There were a few other points that you can pull out of that study. They fielded the study to a total of 853 individuals who were drawn from different sectors of our community. So some of them were police officers who do the interviews of the child sex abuse complainants. Because the issue is, if they know certain things or don't know other things about human memory, that might impact the way they ask questions, the inferences that they draw about the accuracy of the complainant's report, and whether that interview gets investigated later on and referred to the prosecution for potential trial. So they knew that the police were very key in the process. They also fielded the survey to the general public, who are our jury-eligible population. So I know that here in Hong Kong, as in Australia, you do have criminal jury trials where lay people who may subscribe to the same set of beliefs as the people in the Akhtar survey might be called upon to decide similar cases. And the third population group from which they drew were people who did primary memory research. And their goal was to try to see the extent to which there was agreement or disagreement on those 36 items by those 3 different sectors. And they found that there were significant differences that emerged between beliefs about memory held by the lay public and the police together versus the memory researchers. And in fact, they did a full-scale factor analysis of how those beliefs clustered, and the factor analysis revealed 8 different constellations of beliefs, which they called either the scientific memory belief system that was endorsed by those familiar with the memory research findings, or the common sense memory belief system that was endorsed by the police and endorsed by the lay jurors. In a nutshell, because I don't have time to go in detail through the findings of that study, the common sense misperceptions included things such as memories are continuous and complete, they function pretty much like videos and photographs. The lay people and the police also thought that accuracy was indicated by good memory for details. So that if, for example, you went home and somebody asked you, what were the furnishings in this room like, and you could remember diagonal stripes or something like that, that sort of detail, or the color of the chairs or the texture of the chairs, that would indicate that you had a reliable memory for perhaps my lecture or some other event that you experienced in this room. So looking at correlations between details was considered very important by that group. and vivid memories described in, with strong adjectives, maybe visual depictions or sensory detail were also regarded as cues to accuracy. The scientific group, on the other hand, had very different memory beliefs. They expected memories not to be continuous, but to be very fragmentary. They expected also that the number of details and their nature should not predict accuracy of an event memory. And they also were very attuned to the fact that people could produce vivid descriptions, people could produce details, but they might be in error and even false due to the way that human memory processes operate. So what we learned from this wonderful study by Akhtar et al. Was that it raised the probability of flawed judgments by lay people, such as the jury, about memory, as well as by the lawyers running those cases and creating the defense and calling the opportunity witnesses, and that these sets of beliefs, whether held by judges, police, or jurors, may in fact lead to one of the other starkly surprising findings in the judicial system, which is not only do these cases of sexual abuse occupy approximately 40 to 50% of most courts' workload, but the attrition rate, the acquittal rate, far exceeds, it's more than double, sometimes triple, the rate of acquittals in other similar crimes, contemporary crimes like robbery, something other than sexual assault or sexual abuse. So perhaps misunderstandings of memory are really contributing to this high attrition rate was one of the issues that our mission became to explore. This slide here, and I won't go through all of them because we'll come back to these details, is just a summary of the 8 factors that Akhtar et al. Produced that distinguished the expert memory system from what they called the common sense memory system. There are other individuals, aside from Akhtar and colleagues, who have highlighted the fragility of human memory and the way that memory operates. And I wanted to highlight some of those by Akhtar as well, a North American memory researcher who divided memory errors or memory fragility into 3 different kinds. He said we have errors of omission, commission, and persistence. They called the deadly sins. So there's an overlap between what Akhtar et al. Found and some of these. I just wanted you to get another viewpoint on issues to do with memory. The issue of memory transience has to do with the durability, and we were very interested in durability. And what Akhtar et al. Have highlighted is that once you have encoded a memory and it gets stored in your long-term memory bank, unless you use it, you tend to lose it. And it becomes very difficult for you to retrieve it unless you have certain specific retrieval cues that will somehow trigger that memory. But you can't necessarily just voluntarily retrieve a memory, even if you encoded it accurately and stored it accurately. So that's one of the fragilities in the system. So knowing what is a good retrieval cue is important, and especially if you're a police interviewer or an investigator or a lawyer or a judge at trial. Certainly, if you're inattentive at the encoding stage, when you're actually experiencing something, then you will miss things that are very obvious. And what I wanted to highlight here too is a separate memory phenomenon, which is called inattentional blindness. You may have heard of inattentional blindness because the studies that were done to demonstrate just how little we encode and what happens to our encoding process, which determines what gets into our long-term memory, were quite dramatic. And one of the most dramatic studies of inattentional blindness you can find if you just Google those words yourselves and look for the gorilla study. So we call it the gorilla study because what happened in this memory experiment is that the researchers set up two different teams of individuals who were the research participants, and they were passing a ball among themselves. So there was a team wearing a white t-shirt and a team wearing a black t-shirts, and they each had to pass the ball. And then they had some observers who might be like the experiencers of an event. So the event is the passing of the ball, and they're experiencing it. And they were asked to count how many times their team, either the black t-shirts or the white t-shirts, passed the ball. So they were focusing their attention on the passing of the ball and counting. And at the end of it, they knew that they were going to be asked, how many times did your team pass the ball? In the middle of the ball game, a 6-foot individual dressed in a gorilla suit weaves in and out of the ball players. Taller than most of them, very obvious, dressed not in a white or a black t-shirt. And what people learned from that study is that if your attention was focused on counting the number of ball passes, 50% of the observers did not see the gorilla. Very vivid kind of study that shows just how much we lose at the encoding phase, for example. Blocking, another omission error here, refers to the temporary inaccessibility, when you know you've got something in your memory but you just can't bring it into conscious awareness at that time. It happens a lot with labels or names. We've all experienced it, but it can also occur due to other reasons. And one of the blocking phenomena that I'm going to talk about a little bit later is blocking due to trauma. One traumatic response is to avoid memories that are unpleasant and to block them voluntarily from refusing to engage with them. So then they fall into that use it, lose it category because you're not accessing them, becomes harder to remember them. So you can see that there are some quite useful concepts here for our issues to do with historical abuse. Most of these here about commission have more to do with biases that individuals have when they're either searching their memory database or forgetting sources, taking memory from time A and thinking, transposing it to time B. So when you're asked about time B, you telescope that information from time A into your retrieval, and you produce an error, not because you don't have a real memory, but because you're mixing up the source. That's fairly common in a number of ways. And the notion of suggestibility has to do with how much we can absorb information at the retrieval phase that itself can contaminate or make the memory trace, which is malleable, modify in some way or another. And many studies have looked at that. By persistence, really, what Schachter was focusing on was persistence due to trauma. The idea that you might sometimes have involuntary memories that just come into your mind during conscious awareness, or sometimes during the nighttime, during your sleeping state, in the form of nightmares. So daymares and nightmares can be examples of repetitive, involuntary, intrusive memories, most of which are negative in nature. And those can be your inability, therefore, to forget things. That doesn't mean that they were encoded accurately. All right, so with all of that research background, what we did, to summarize the literature and further condense it, was try to think of what might be the top 10 points that we think the judges and lawyers and prosecutors and police and jurors should know about human memory today, where we know there are common misconceptions along the lines of what Akhtar et al. Discovered from their factor analysis. And the first important point as an overview is that the kind of model that you hold in your own mind about human memory can in fact shape your expectations of witnesses. So that if in fact you think that memory is photographic or works like a DVD recording and is complete and continuous, then if you are questioning a witness at a trial or during an investigative interview, you might think, if we just keep sitting here and asking more and more questions about the event, this individual will retrieve more and more information and they ought to be able to fill in all the gaps. In reality, that's a misconception, and our models of memory have changed with technology. We used to think it was much more like maybe the Dewey Decimal Library System. If you just got the right decimal number, you could retrieve the memory. But now we know, as Connolly has said, that memory is not really like that. It's more like an improvisation. And every time you play melodies back, there'll be some bits that change based on a similar theme. So that if you're taking the same memory that you have and you're telling the story to a different person than you did the last time, you don't necessarily relate that memory in exactly the same way as you related it the first time. It differs each time it's played back. And so there is no underlying, videotape accuracy to cross-check it. And each time you store it and encode it, it may be encoded a little differently as well. So when you see in my slide set, that number, the Arabic number 1 through 10, that's one of our key take-home points about memory processes. And when you see, such as on this slide, something in bright yellow text, that is usually one of those common sense errors or misperceptions about memory. So what many people think is that adult autobiographical memory exists for early childhood events. This ignores a very well documented phenomenon that's important in cases of childhood sexual abuse called childhood amnesia or infantile amnesia. And good research by Rubin, for example, and others, has now shown that, in fact, the amnesia period can last as long as approximately 9 or 10 years of age. So how does that work? Well, it's not that children cannot remember what happened to them or that infants cannot remember what happened to them. They remember quite well. It's that from the perspective of adults or late adolescents, when we look back at our early childhood, we tend to have very few fragmentary sorts of memories and mostly gaps. And that is what the amnesia period is. And it does decrease as you age. So you might have 90% of a gap for under 2 to 5 years of age. And then 5 years of age to 10 years of age, you might have fewer gaps in your autobiographical memory. But most people's early childhood memories are not so much from their own episodic autobiographical memory traces. They are from learning about their early childhood through family members, by looking at family photographs as adults, that they've learned more about them, and that can be very misleading if it's thought then to be an adult autobiographical memory for childhood. People also tend to think that it's possible for traumatic memories of childhood to be repressed and then recovered perfectly years later, when perhaps you've matured and can reconsider those events. Whereas psychologists do not acknowledge or validate any mechanism called repression. And so we do acknowledge that there are unreported memories that can perhaps be triggered, and we speak about them now as previously unreported memories rather than repressed memories. So that's a major error. The second take-home point is that gaps, not only during the childhood amnesia period, but gaps in all of our memory processes are in fact features of normal memory. To the extent that British researcher Mark Conway really specifies that a hallmark of a normal memory, especially if you're looking at a legal case, is somebody who has gaps in their recall. So if they come to you and they seem to have a full-scale, videotape-like narrative, he would say you should be suspicious that perhaps what you're seeing is a production that is not realistic, whereas someone who does admit memory gaps is more likely to be honest about that experience. They've also highlighted that people who are lying and deliberately deceiving are less likely to admit gaps in their memory, but will try to fill them in based on their general conceptual knowledge. Because many types of deception or lying draw on real experiences and then fill in gaps based on inferences about how we know the world might work. They don't want to admit gaps because they think that that will be a giveaway that they didn't have a real experience. So that's become quite a useful way to distinguish between genuine memories and memories of deceivers. In the Pell case, and I'll return to some examples from the Pell case along the way to show how these features apply, the defense argued that because the complainant admitted memory gaps, his accounts were not reliable, and therefore he should be discredited as a witness when reporting events of child sexual abuse. And so in that Court of Appeals decision, the dissenter took that view, whereas the majority, the two judges who upheld the jury verdict, had a different understanding. They said that they thought that the sort of memory blanks that the complainant had were the kind that you would expect a person to have about unimportant details or peripheral matters, given the passage of time, the duration lapse, and given the lack of significance of some of those details that he had forgotten to the actual core event of abuse about which he had more full-scale memories. So the admissions of the gaps to the Court of Appeal were in fact markers of veracity and indicators of high credibility rather than deficits. Very different to the dissenting approach. All right, so my third take-home point is that memory for traumatic events is different because these can disrupt the encoding and the retrieval process. And as you can tell from what I told you about the ACTAR study, that's one of the key areas where memory misconceptions by laypersons tends to play out. The Pell complainant's demeanor was generally very calm, very matter-of-fact. Only at one point in his trial did he show any emotion. He became a little bit angry when he was cross-examined as to why he had never discussed the abusive events with the now deceased co-complainant. And he did have explanations about why that wasn't discussed. But the majority in the Court of Appeal decision thought that his demeanor and the level of emotion that he showed lacked any contrivance. It didn't appear to be false, whereas the dissenting judge was looking much more to those Eggleston cues about wanting emotional intensity as an indicator of accuracy, using emotion as a cue to credibility, and so he was more critical of the flat affect or demeanor. Most research on child sexual abuse victims looking at their accounts has noted that while some might display emotion, by far the majority tend to have a very flat emotional affect. And so that if you do rely on tears or emotional displays, that is a misleading feature, a misperception about accuracy. That intensity does not mean accuracy. Similarly, if you think that the vivid descriptions are correlated with accuracy, we have learned that vividness, through many studies, is not correlated with accuracy, seems to be independently produced by a witness, so shouldn't be that cue. Right, and now on to the fourth key point about how memory works for recurring events that I indicated was such a critical distinguishing factor between the opportunity witnesses by the defense and the complainant's evidence. So what we've learned is that we often have to give evidence in many cases about recurring events, whether it's an abuse case or not, even if it's a civil trial about companies' policies and procedures or what happens in the workplace. Oftentimes witnesses will talk about how things are normally done. That was the sort of evidence given by the opportunity witnesses in the Pell case. The one-off events are going to be those that are rare, they're distinctive, they stand out. The multiple events cases are those that are over and over the same. We know that when there is a series of repeated events that are similar, like abuse that occurs over and over again, there might be some parts of the abuse that are identical and similar every time, and a few things that are a little different from one time to another. So if there are invariant features, which are highlighted there in the red, that might occur over and over again across multiple events, what the brain does is to try to generate a schema or a script for what is predictable, what has happened before, what we know, what we're familiar with. And that would focus on the invariant or repeated features. And once we have developed that template or a schema for what is predictable, then we stop encoding those features. And we might focus on the variant features that are unique and different every time. And a number of studies have been conducted looking at people's memory for the invariant and the variant features, and they have found that with multiple repeated events, there tends to be more source confusion. People can remember the gist of what happened quite reliably, because that's what might be recalled in the template, but the details as to whether something happened at time 1 or time 3, if there are 40 different repeated events, become very murky and fuzzy. They're not encoded and they're not in the memory system. So you probably have a template for how you conduct your day-to-day routines, so that if you are asked today what you had for breakfast, while it's still very fresh in your memory, you can remember what you did. If I ask you about that sort of repeated event and which day, in the past month you had X to eat or Y to eat, you might mix up those days because you haven't encoded those details of those repeated memories. And so what the Royal Commission noticed in all of its hearings by the 67,000 individuals is that those who had been victims of multiple incidents of recurring abuse tended to have very impoverished memory accounts compared to those who had been abused only once or twice. And they wanted an explanation from human memory research as to why this was. And in fact, it was such a stark contrast that they thought that the individuals who were abused the least, paradoxically, were the most credible and persuasive, and those who were abused the most often just seemed to be able to recount a vague gist of what happened over multiple times and appeared to many of the legal professionals to be less credible. So if we look at how this worked in the Pell case, we saw that the defense relied on these opportunity witnesses to say what would typically have happened in every Catholic church service. And although there was some uncertainty looking back 20 years as to exactly what those liturgical practices were in Melbourne at that time, they had a good gist memory for those repeated events. But as soon as you had to try to pin them down to the specific instances that were the complainant's dates of the alleged abuse, they had no episodic memory trace for those events because they had retained the core or gist. And so their answers were typically, I don't believe so, I don't know, I don't think so, very vague. And that is an example of what we would call conceptual knowledge about those idealized procedures that wasn't drawing on the memory bank for episodic memory. As I've indicated, with a schema in place, you tend, if you're an adult or a late adolescent, you rely on your world knowledge to fill in the gaps. And so these individuals were doing their best using their schema memory, but were unable to provide very satisfying memory traces of specific instances. By comparison, the Pell complainant's memory was individual episodic memory traces for unique, distinctive, standout events in his autobiographical life. And the majority in the Court of Appeal, the two judges, said that the particular sexual conduct in issue and where it occurred, the location, were very likely to have been the details fixed in his memory in a way which could not be said of any of the other witnesses who appeared in that trial, just because of the uniqueness of those events. None of the defense opportunity witnesses could confirm that the alleged conduct was, in fact, impossible. Even though they were called the impossibility witnesses, they had no episodic memory trace to rule out the events that the complainant asserted. Some of them were very aged witnesses by the time of trial. There was one gentleman by the name of Mr. Potter, who is over 80, in his mid-80s at the time of trial. He was fairly certain when led on direct examination, as soon as he was cross-examined about what he had stated, he became muddled and confused dates and events and so forth, which is very typical with elderly witnesses. We know that as you age, your memory processes become less acute, and he was a sincere witness behaving like a typical mid-80-year-old witness in giving that evidence. So we know that the scientific memory findings are that memory for repeated events, relies on the schema formation, and as I highlighted from Schechter and others' work, biases can occur at different times, and you're reducing things to a semantic gist, conceptual gist, versus that fine-grained memory trace. All right, so moving on now to the next big take-home point is how sensitive our memories are to retrieval cues. In dealing with young people to get accurate memories, a number of good protocols to interview witnesses have been developed in different places around the world. One of those is in the UK, is the National Institute of Child Health and Human Development, which has produced a set of guidelines that are very well regarded. In the United States, a group of researchers use what is called the DNE, or the Developmental Narrative Elaboration Interview. There are many commonalities between these two approaches. The cognitive interview is quite popular with adults. It's regarded as a little cumbersome to use with children, and it capitalizes on what we know about how memory is encoded, stored, and then retrieved. So, for example, a common cognitive interview technique is to try to get people to adopt different perspectives and then try to remember an event from different perspectives, trying to capitalize on encoding sensitivity principles that apply. For example, if you have studied some information in this classroom, and then you do your test in another classroom next door, you don't perform as well as you would do on the test if you were tested in the same room where you studied that information, because you have encoded things within a specific environment. When you are tested on it and you have to retrieve it, that environment itself can be a cue that assists you in better retrieving the information. So quite effective as a cue retrieval aid can be a visit to the place where people have alleged that an event occurred, because features of the environment that were encoded by their senses will often be salient then and help them to retrieve that underlying memory. We know that using open-ended questions produces a memory report that is less susceptible to error. Using closed-ended questions, such as are typical on cross-examination or typical in many legal proceedings, provides information to the witness and can mislead them or lead them to incorporate more errors. And especially, for example, young children might think then that they've forgotten something that is suggested in a question and pick it up. Questions that pose options to people are not as effective, just as are leading questions. So we advise that people avoid those. The defense and the majority looked at the complainant's evidence again in very different ways. When looking at some of the details of the evidence. So what happened while the Pell complainant was giving testimony at trial is that he provided some new information that had never come up, never been provided by him in the police interview or the investigation. And there were a couple of other details that were changed when he gave his evidence at trial in comparison with what he had said earlier. So the defense looked at those and said he must have deliberately and strategically tried to change his evidence to make it seem more plausible in light of what he knows now about the circumstances. So they were suspicious of those changes, and they had to do with where he had been, where the cardinal had been, and where exactly the choir boys went off to the sacristy and how they got there. The majority in the Court of Appeals decision believed the complainant when he said that he hadn't reported those details before because no one had asked him the question that way before. So he was, without knowing about memory research, he was in fact referring to cue retrieval processes, saying, now you've given me this cue, now I remember something new that I didn't report before. It's not that he was trying to be deceptive, and the majority believed that. And he had also said that he didn't include certain details previously because they didn't seem important to report to the police at the time when he was providing a bigger picture of his experiences. So they dealt with these gaps and the cues to retrieval on cross-exam in very different ways. We know that individuals have difficulty remembering times and dates with great specificity, especially when a number of years have passed. Sometimes it's easier to use landmarks as retrieval cues, like, was this close in time to your birthday or Easter or Christmas or some event that is familiar. It can be a bit tricky with children because children tend to have memories that are prospective in regard to landmarks. So if you ask them about a birthday, they'll think about the upcoming one rather than the one that's just passed, until they get more familiar developmentally with the way that adults use cycles of time and with formal temporal reference. Pell got somewhat confused about the dates when the alleged abuse happened. So in his initial police report, he said that both incidents had happened in 1997. Then later on, during the follow-up police investigation, he said he'd made a mistake and he thought that both of the events, the sacristy and the corridor event, happened in 1996. And then at trial, by which time the lawyers had a great deal of information about exactly which days Cardinal Pell had given a mass and which days he hadn't, and they were able to piece things together with a calendar, the complainant was settling on the evidence that the first incidents happened in December 96 and the second one, fairly close in time, in February of 1997. So legally, there's usually a great deal of controversy when people's evidence on details about, the timing of the core event changes. The dissenting opinion in the Court of Appeal thought that those date changes were without any sufficient justification and were a matter of great concern for the reliability of the complainant. So used that as a basis to reject the evidence and say beyond reasonable doubt could not be met because of those date changes. The two judges who jointly authored the majority opinion said, this is the kind of detail about which honest witnesses make mistakes, dates and times. So they were much more in tune with the empirical evidence, which shows that normal autobiographical memory of adults is replete with what we call self-contradictions about dates, times, who was present, who wasn't present at events, and that people are notoriously bad at reconstructing time frames such as Pell's complainant was required to do. And that if you're required to do this from a childhood time frame, you have even less of that sort of temporal framework to draw upon because of your young developmental age. So very different responses there. Right, now I'm going to talk about the issue of repeated interviews. So obviously the Pell complainant was interviewed a number of times, and I've just highlighted some of the differences in his evidence that emerged and developed over time as those multiple interviews occurred. Very often, police interviewers and people who work with complainants in sexual assault and child sexual assault cases have wanted to avoid re-interviewing a complainant, first of all to protect them so that they aren't re-traumatized by having to relive and retell an aversive, unpleasant, negative, abusive experience. But another reason that there's been a great deal of concern in the law about re-interviewing is that they don't want to have disparities emerge that weaken a complainant's case. And this all comes from that misconception that memory should be an accurate, complete videotaped recording without error. So if you can accept that memory is full of gaps, that errors with dates are normal, then you shouldn't be concerned to this degree about repeated interviews. And in fact, what we have found as psychologists recently is that when multiple interviews are done, this can foster what is called incremental reporting. As people remember events and then go away and think about them, perhaps their memory synapses percolate a bit and they remember new things that they didn't say in the interview. And then they come back and in the second interview they add it, or it's incremental, it grows. And sufficient evidence of that phenomenon exists so that there have now been studies comparing the accuracy of that information that is produced during the incremental reporting. And this is often called the reminiscence effect as well in some of the literature. And what we know is that those reminiscences are almost over 95% accurate. Some studies might say 97% accurate or higher. They have a very, very high accuracy rate. So the take-home message to the legal profession is do not be deterred and in fact pay attention to the subsequent memories. So perhaps if we applied that to the Pell complainant, we would feel more secure that that final evidence that he gave about the timing and the dates of the abuse was likely the most accurate after all of the reconstructions. Now, those last few points also highlighted the role of inconsistencies, which the law has abhorred in terms of assessing a witness's testimony. So if you remember at the beginning of the lecture, I talked about the 6 Eggleston factors, and inconsistencies featured in a number of them. What the research shows is vastly different than what legal doctrine applies. So whereas legal doctrine uses inconsistencies to argue that a witness is unreliable, what contemporary psychological researchers know is that inconsistencies are normal. and that those might be inconsistencies with one's own evidence, inconsistencies with other people's evidence, whether or not they're self-contradictions or not, we should learn to expect them and not be surprised. And we should not regard a witness as lacking in credibility when self-contradictions and admissions about contradictions and inconsistencies arise. In the Pell trial, something very extraordinary happened in Victoria, and it happened as a result of the Royal Commission into Institutional Responses to Child Sexual Abuse. Because of that memory report that I co-authored with Mark Nolan and Evian Grosvenor-Franquin, there were in fact some reforms that were proposed by the Commission that had already been implemented in Victoria by the time the Pell complainant gave his evidence. And in fact, the Victorian Committee on Jury Directions drafted a specific direction that took into account our memory advice on inconsistencies. And that jury direction was part of the charge given by the trial judge to the jury in the Pell case and repeated for them by the prosecution. And it was a way that the jury then had to look at the inconsistencies and the new details that emerged during that complainant's evidence. So the majority went along with that instruction. The jury directions basically said that if the inconsistencies and the errors were about what we call peripheral details to a central event, those are common. And they do not indicate that somebody is not a reliable, sincere witness. So the majority said that the inconsistencies were unsurprising given the 22-year delay and given the fact that there were many repeated events and rituals in liturgy that were recalled, and that the empirical underpinnings that we had provided in our report were guidance to them and may have in fact made a difference to that jury and led that jury to find beyond reasonable doubt that the abuse occurred notwithstanding those inconsistencies and contradictions by the complainant. Because what we said in our report was that those inconsistencies were not predictive of the accuracy of core memories. So we advised fact finders to consider the type and nature of inconsistency, just as we had advised regarding the reminiscence effects. And that study by Fisher et al. Is one looking at the correlations between minor inconsistencies and core events and looking at reminiscence effects and core events to produce those reliabilities. Right, now we're up to take-home point number 8, and that has to do with the durability of memory. One common misconception in the law is that your memory trace is fixed at an early point in time of the event, and then it just slowly fades and disappears until it is gone. And the quotation there in yellow comes out of a legal case. This happened to be one in the United Kingdom, but we cited it because it so much captured the common judicial view of how memory should be fresh to be more reliable. And that indicated some inaccuracy, not only in the rate of decline of memory, but also a complete misunderstanding of what might keep memory strong and durable. So I wanted to spend just a moment on that. What we know mostly about forgetting rates has come from about the mid-1800s. A researcher by the name of Ebbinghaus studied his own memory. And he would engage in various activities, and then he would write down notes about what he could remember versus what happened at the time, and calculate how fast he forgot. And he would do this at different times. And what he found is reflected in this Ebbinghaus curve, as we call it. And if you can look at the timeline across the bottom of this graph, you will see that, in fact, the greatest drop-off from 100% down to, about 70% occurs very rapidly in about 1 day, 24 hours. And then it just, is regarded as going slowly down after that, not at quite such a dramatic fall. So it's more like falling off a cliff than that slow gradient that the court assumes. But what happens if you engage in memory maintenance activities? Memory maintenance activities can pretty much reverse the effects of the Ebbinghaus forgetting curve. And if you look at the timeline across the bottom of this figure, you will see that the number of rehearsals or repetitions that you have of information can dramatically preserve it. So the blue line here is more like the Ebbinghaus forgetting curve, and all of those others up to the very light blue or lilac line with the fourth repetition shows just how much difference can occur with the strength of a memory trace and what you can retrieve from memory if you have rehearsed it or repeated it. In normal everyday life, just thinking about a prior experience is a form of rehearsal, and then you might store it back in your own memory bank. If you have engaged in conversation with others or reported it, that is a form of rehearsal and strengthening of the memory experience. Most commonly now, we know that with young children, if parents engage in dinner time conversation about what happened during the day, especially mothers do this with their children, perhaps when putting them to bed. They ask them about the day's events. That develops your autobiographical memory system, and it develops memory maintenance strategies that people can use for their entire lives. So children who have good, attentive parents who engage in that kind of discussion with them have what we call a memory scaffold that develops that strengthens their autobiographical memory. If you take this child of the same age who's been very neglected, does not have an attentive adult or friends with whom they're discussing and rehearsing their memories, that individual tends to emerge with what we call a very shallow autobiographical memory that might lack all of those scaffolding features, so that even their own self-identity can seem quite impoverished in its development by comparison. So some of these are naturally occurring. They're not necessarily just through formal study in a classroom that this repetition and rehearsal can make memory much more durable. Take-home point number 9 has to do with comparisons of memory systems across the developmental trajectory. So I've highlighted that very older adults in the upper elderly years in our society have a decline in their memory abilities. What we have learned through many studies of developmental memory in young children is that in fact their memories are no different in the way they operate. So they still use the same encoding, retrieval systems and consolidation systems. They just have lesser capacity. So if they're exposed to an event and an adult is exposed to the identical event, the child will come away remembering less about it because they will have encoded less, because their brains aren't as well developed. They don't have as many knowledge systems in place to help them encode information more efficiently, but they will still have the capacity to remember things accurately. They may simply, if they're given open-ended questions as a memory prompt, they may retrieve less from their memory system, but it'll be the same process as their adult counterparts are using. So it's not that there's anything different or alarming about infant or early childhood or adult memory, just in terms of the way it operates. Pre-verbal children will remember things through action, and they will enact them then through what we call deferred behavioral imitation. So instead of using language to recount things, sometimes they enact sexual conduct that's indicative of them having been abused if it's not behavior that they would have been exposed to in any other way. That can be one way that is conveyed through their memory system. A great deal was written in earlier years for the legal system about children's memories being very suggestible, and that adults, by comparison, were less suggestible. So it was a developmental argument that was made that led many courts to mistrust people's memories of childhood, even given historically, as well as to mistrust evidence given by children while they are children. And what we found in doing our memory review is that since the British Psychological Society finished its work, starting in about 2008, there has been a surge of new literature that has reevaluated many of those same old studies, sometimes by the same researchers, including, for example, Professor Stephen Ceci from Cornell University, who was one of the leading researchers on children's suggestibility, is now one of the researchers who is writing about what are called reverse developmental effects. So a developmental reversal effect implies that the younger individuals are doing better than the older individuals, not what was assumed hitherto. And the reason for this, again, has to do with that key distinction in the Pell case between episodic memory systems and semantic conceptual memory systems. So while children are young, when they experience events, they're very focused on their episodic event memory, using their senses to encode new experiences in a rich way and to store them and remember them. They do not have yet a great deal of general world knowledge to refer to. They don't yet have a great deal of schema memory that is developed through repeated similar experiences to refer to. And so when they're questioned about events that occurred in the past, what they resort to when they're retrieving those memories is to that initial episodic memory trace. Whereas adults who might have experienced the same event at the same time, and there's some very good studies of children and their caregivers or adults or parents experiencing the same event and then coming back to the lab 5 or 6 years later and being exposed to the same memory questions about that event that was staged by the researchers. This is work done, for example, in New Zealand by Harleen Hain and colleagues that has led to some of these findings. What they showed is that the adults' memories were much more susceptible to error, because the adults relied on their general conceptual world knowledge and then filled in their gaps in their memories based on how they know the world usually works. That's what we tend to do once we reach late adolescence and adulthood. We rely so much more on drawing those inferences from our world knowledge to fill in the gaps in our memory. So that meant that if you were just testing children and adults, and studies have been done in every single one of those situations listed there: personal experiences, event participation, identifying faces familiar to them, resisting misinformation in suggestive questions, resisting social pressure to agree with others, regarded as another explanation for children's suggestibility, withstanding the delay of as much as 5 or 6 years, and even simple semantic word list tests where people are given a list of words that they're exposed to, and then they're shown a group of words and they have to pick out the ones that they recognize. In all of those situations, children's event memory, it is now stated, is not significantly related to suggestibility. So this is actually quite important news for the legal system that typically gives jury directions saying if somebody is a young adult or a child, be cautious, unreliable witness. So this is a new way of looking at it. All right, so that concludes my summary of what we regarded as the top 10 memory facts for the legal system to take on board in looking at historical memories. So I just want to finish up by summarizing now a few last points about how I think this leaves us with the Pell case. In drawing together that 125-page majority opinion and comparing it with the 175-page dissenting opinion from the Court of Appeal, and their application of those 6 Eggleston factors to evaluate the complainant versus the 20 or so opportunity witnesses to see whether there was reasonable doubt in that jury's verdict, what we noticed was not only all the details that I've given you already about how they diverged, but we noticed one key difference in the way they approached memory, and that was that the defense, or the minority, focused on looking at a witness in a sense holistically, and looking at, what is that individual's social standing, their education, what kind of background do they have, what other factors might be indicators of demeanor, etc., to form an opinion overall, holistically, as to whether that individual was generally a reliable or unreliable witness. They did not assess the memory type, and they did not assess the event memory of those individuals. So, for example, the dissenting judge simply classified all of the witnesses, said these witnesses are good and reliable, without going in detail into what they had actually said. The prosecution and the majority who upheld the jury verdict had a different approach. They evaluated event memory and issues that affected the different witnesses' recall of the specific events that were at issue and at stake in the case. And they analyzed those events by witness. They did not analyze the credibility by witness generally. So they went bottom up from the event rather than top down from the witness. This is much more compatible as an approach with what I have summarized for you as contemporary memory research empirical evidence. It allowed them to be much more analytical about the complainant's testimony instead of conclusory about his evidence, and it also allowed them to take on board those empirical findings, such as the jury direction on inconsistencies, that obviously was critical in a case where, in a word against word event, there were some inconsistencies by the key witness. All right, so again, I've just summarized here the highlights of the differences. I think many of the defense and the dissenting judge's opinion endorsed more of the common sense notions of memory. Many of the prosecution, drawing on our memory report, and the judges, drawing on the prosecution's presentation, focused much more on the science of memory as we summarized it. Okay, so that is how I would sum up the value of looking at this kind of empirical-based research report commissioned by our Royal Commission in applying it to a new case that is before our High Court. We very much anticipate the decision, and as I stand here today, I do not know whether the High Court, consisting of 7 judges, is going to take more of a common sense approach to memory and follow the kind of Eggleston analysis that the dissenting judge did, or whether they will follow what the majority did. So that is something we will learn later in 2020. We understand that about February or March, they may have a hearing on it, and then sometime later in 2020, they will issue the decision as to whether Cardinal Pell's jury verdict is overturned and he's set free, or whether he serves the rest of his prison sentence. A final caveat that I want to leave you with is that obviously the empirical guidance that we put together in that report is a set of general principles about general memory processes. It doesn't really explain individual differences, By that I mean there can be some individuals, we know that there's a very small group of individuals who seem to have an extraordinary episodic memory trace. It's a very tiny percentage, less than about 1% of the population of individuals who, if you said to them, what did you have for breakfast on the 20th of November in 1996, they would be able to tell you. That there's something about their memory systems that is just different. They are studied. So what I have given you is a depiction of more like 99.9% of individuals' memory systems. Not, could be one day you'll have a trial where you'll get one of those super rememberers with that super episodic trace. That doesn't mean that their episodic trace is accurate. They're still susceptible to how they understand the world, filling in gaps from their general knowledge, etc. So just because you have a fabulous episodic trace doesn't mean it's nonetheless bulletproof. We provided this guidance to give some empirical basis to assist courts, as we've suggested. There wasn't time today to talk about all of our references. There are footnotes and cross-references from the chapter to the empirical literature, if you're interested in those underpinnings. The Royal Commission, in summarizing its recommendations to the criminal justice sector of its activities, cited our report, over 600 times. So they did find some value in the empirical summary that we were able to produce on this topic, in filling some of the mysterious things that they had observed about the way people remembered events of childhood sexual abuse. So we were happy to have the chance to contribute to law reform from such a proactive entity as a Royal Commission, much faster than having it done by court, because legislative changes are in the wings, quite far-reaching ones. And that would be the topic of another whole lecture on law reform processes drawing on empirical research. So I'm going to conclude there. Thank you very much for your attention, and I'm happy to take questions if there are any.